Welcome. We're delighted today to have a very special guest, the Honorable Enver Hasani, President of the Constitutional Court of the Republic of Kosovo. President Hasani has received his first Master of Laws degree in Civil and Economic Law from the University of Pristina, Kosovo's largest and oldest institution of higher learning, and his second Master of Laws degree and his PhD in International Law and Relations from Bilkent University in Turkey. Before his appointment to the court, President Hasani served as legal advisor in the Ministry of Foreign Affairs of the Republic of Albania from 1992 to 97. He served as the head of Kosovo's Office for Foreign Relations from 2004 to 2006. And he subsequently was rector of the University of Pristina after serving as dean of the Faculty of Law and professor of law of this university in prior years. Since 2008, he has served as president of the Constitutional Court and was just re-elected to a second term in 2012. Under his presidency, the Constitutional Court has been a powerful and independent body serving the rule of law in Kosovo. During his professional career, President Hasani has published numerous academic articles regarding different aspects of civil, constitutional, and public international law and international relations. He's published 4 books in the field of international law and international relations. 2 of those have been published in English. President Hasani has been a visiting professor at Northwestern University and a guest lecturer at Harvard. We're honored to have him with us today to speak on the role and positions of the Constitutional Court on the Southeast Europe, the role and positions of the Constitutional Court on the Southeast Europe with special reference to Kosovo. Please join me with a warm welcome to the Honorable Enver Hasani. Thank you.
Thank you, Dean. It's a great pleasure for me and the institution I represent to share my views on the topic of constitutional justice in Southeast Europe with special reference to Kosovo. I thank you and your colleagues for inviting me and giving me this opportunity. As you can see from the title, I will try to speak like 20 minutes to be as brief as possible, so that leave 20 other minutes, the rest, because I presume that some of you might have questions or inquiries regarding the topic. Constitutional justice in Europe is a phenomenon that developed between the 2 wars. And it's associated with a name which every lawyers know. It's Hans Kelsen, who was the first in Austria to institute such an institution, which, of course, as we might imagine, collapsed with the rise of the Nazis to power and the Anschluss of Austria. But the idea remained vivid and was part of a fervent debate which is still quoted between Hans Kelsen and one of the most famous Nazi supporters of the time, Carl Schmitt. For those years, when today one would read the debate between Kelsen and Schmitt on constitutional justice, would see how visionary Kelsen was regarding constitutional justice. Of course, it had to pass a time and human tragedy of the world scale for the idea to come to the form and format that as it stands at present. The idea of the debate over constitutional justice was that there should be, as Kelsen put it, a separate institution which will be insulated from the regular court system, in charge of interpreting the Constitution and seeing whether the law or legal norms or legal acts conform to the higher act as it was known in German terminology, then Grundgesetz, that is basic norm, Grundnorm, basic norm, meaning the Constitution. On the opposite side, Schmidt denied this because it said that it cannot be a judgment of the norms against the norms. There cannot be a court which would deal with judging whether a norm, legal norm, conforms to the Constitution. Of course, neither Kelsen nor Schmidt would those years imagine that the constitutional courts of Europe in the years to come would have, in addition to reviewing the constitutionality of legal acts, a competence, what is now known as constitutional complaint, which exists in Kosovo and in many, as I will be talking later, in many countries of former communist Europe, but as well in the constitutional systems of well-established Western democracies such as Germany, for example, or Spain, which they call amparo. As I said, the idea which was materialized in Austria and Czechoslovakia was very weak. For example, Czechoslovak Constitutional Court reviewed only 2 laws during its interwar existence. And the position, constitutional position of those 2 courts was very weak. That's why they collapsed. It was, in fact, an idea of the Weimar Constitution as the first liberal constitution of Europe, whose Chapter 2 regarding the human rights foresaw pretty elaborate mechanism for their implementation. The end of the World War II gave rise to the birth of first constitutional courts with the different posture, much more stronger than the ones existing in the interwar times. We are talking here about the revival of Austrian Constitutional Court and the establishment of 2 new constitutional courts, Germany and Italy. While Italian and Austrian Constitutional Court didn't recognize constitutional complaint, that is, legal mechanisms in order to implement through an institution such as Constitutional Court human rights and fundamental freedoms or charter or bills of rights existing in their constitutions, German Constitutional Court was brave enough because it foresaw, their constitution foresaw as early as the 50s for individual complaints procedure, that is, reviewing of the constitutionality of every public act, of every public authority in Germany, including Supreme Court of Germany. If you see the raison d'etre of these 3 courts, you would see, as it was in American Political Science Review, wonderful article published by Hans Kelsen himself in the 50s, was to clear or to break up with the Nazi legacy or the fascist legacy of these 3 countries. In fact, the same as we will see happened with the 2nd and 3rd wave of the establishment of constitutional courts of Europe. That is, with the breakup with the dictatorship past of the certain countries of Europe following the end of the Second World War. As you see, second wave of the development is Spain, Portugal, and Greece. While Spain and Portugal, in fact, Portugal has what is called mixed tribunal, mixed constitutional court. Spain has a clear-cut example of the German-type constitutional court, which foresees, in addition to the abstract review of the constitutionality of laws, a wide and ample jurisdiction regarding individual complaints procedure, which is known through a Spanish term, amparo. In fact, the origins of constitutional complaint derive from the Latin American societies and were, of course, in a different shape transferred into European soil with different meaning and different content. Greece has a Supreme Court. In fact, Greece and many Nordic countries are modeled upon American system, which we say centralized review of the constitutionality, which every court has the right to set aside the law if the judge or regular courts think that it is not in conformity with the Constitution, leaving in the books, law books as such, not just setting aside, not applying it, if the court thinks that the certain law which is to be applied in a case of controversy beforehand has dubious constitutional value. While centralized system, which is Kelsenian system, to which Kosovo belongs, and many, in fact, most of the former communist countries of Europe and other established democracies such as Spain, Portugal, for example, for that matter, they have centralized, which is, in which case there exists a separate constitutional court in charge of constitutional matters. Sometimes some constitutional courts, especially those in the former Yugoslav territory, they deal even with legality issues. But for the major part, constitutional courts of Europe, they are modeled upon the precepts of Kelsen, that is dealing only with constitutional matters. With the collapse of communism, we see the rise of the constitutional courts, very powerful ones, for example, the case of Czech or Hungarian constitutional courts, in which case, in Hungary, for example, they established until, which existed until 4 years ago, what we say actio popularis, meaning that every citizen, every individual could trigger proceedings before the court without any need to show that he or she has a legal interest in the case, including contestation of legal acts such as laws or decrees of the government or other individual acts of public authorities. Hungarian Constitutional Court was the most activist court in the former communist bloc until, as I said, 4 years ago, when the right-wing government came to power and it basically changed the shape of the court, and now more or less the court is very weak, is politicized, is influenced by politics, and the jurisdiction of the court has substantially diminished compared to the previous times. Czech Constitutional Court has, I guess, the most constant positive record among its peers in Europe. Constitutional Court of the Republic of Kosovo, as it stands at present, is new. It's built at the beginning of 2009, while Kosovo as such had a constitutional court in 1974 based on the constitution of communist Yugoslavia. Every republic and autonomous province, which included Kosovo and Vojvodina, had their own constitutional courts, but those constitutional courts were meant to protect the values of socialism and the unity of power, as it was said. In the constitution of all former communist countries was the opposite doctrine from the Western one on the separation of powers. It was constitutionally guaranteed that the power, they would say, is absolute, is unique, unified, undivided, and belongs to the proletariat, and is exercised by the Communist Party as an avant-garde of the society. It didn't recognize that constitutional court had no clue about individual complaint procedure or about constitutional protection of human rights. Because human rights, every human rights that would appear in Constitution would have a provision which would say the implementation of the rights will be according to the law. Effectively, the law was that commanded the protection of human rights. That legacy basically is not, that's why when you do a research about Kosovo's Constitutional Court, you see very little or no mention at all of that experience of Kosovo during that communist rule. That court was destroyed by Serb dictator Milosevic in 1989, as were destroyed all institutions of the autonomous province of Kosovo. This, the court, as it stands at present, as I said, was established in early 2009 and has one of the widest jurisdiction among the courts, constitutional courts of Europe. It has both preventive, what we say, and repressive jurisdiction of constitutionality, meaning that our court can review constitutionality of every law, both before being voted and after it is enforced, promulgated. Then, referenda, the way the assembly is formed, whether declaration of state of emergency is constitutional, then whether the rights of municipalities are being infringed by legal actions of central government, especially as far as revenues and other rights of local self-government are concerned. Our Constitutional Court has the right to review every constitutional amendment, whether it conforms to the international obligations of Kosovo. Then, every constitutional amendment, before it goes to the vote in Parliament, has to be reviewed by us, whether, and we check it, whether constitutional proposed amendments infringe upon human rights and fundamental freedoms recognized in chapter, what we say, chapter 2 and 3. Chapter 3 deals with rights of the communities. Chapter 2 is human rights in universal terms. So far, we have had, and I will say in briefly now when I discuss about the cases very briefly, we've had so far quashed over 70% of proposed constitutional amendments. We found them that they violate the Constitution. In doctrine, this is called unconstitutional constitutional amendments, meaning that that's famous doctrine, meaning that even before amendments are in force, they are just draft. We say whether they violate the Constitution. It's paradoxical because there is no legal norm, constitutional norm. How can you do this? But this is the European standard of only 4 countries recognize, among them is Kosovo, recognize this type of constitutional review, what we say preventive review of the constitutional amendments. We have so far have had since the beginning 735 cases. We have handled them. Out of them, 80% are inadmissible, declared inadmissible. We say they are not judgment, they are resolutions. We say the case is inadmissible, for example, because there is no authorized party. You have no right to trigger proceedings unless you show legal interest. For example, you cannot ask for the review of constitutionality of a legal norm. That can be done by president, government, and 1/3 of the MPs of Kosovo. This is more or less exists elsewhere as well in other societies. Out of these, 80%, if not more, is individual complaints, constitutional complaints, which are raised by individuals in their quest for the protection, constitutional protection of their rights, constitutionally guaranteed rights and fundamental freedoms. This is the standard elsewhere in Europe as well. Those countries, such as Germany, for example, that has, or Czech Republic, that recognize individual complaints, have 80% individuals appearing before them in 80% of the cases. And out of that, 80% is again declared inadmissible, as I said, for the reasons that are not related with the merits of the case. I will say very briefly, for example, radio and television case. I will single out Prizren Logo case. Prizren Logo case, Prizren is a very multi-ethnic city in the south of Kosovo. Minorities applied before us saying that the statute of the Prizren municipality was only in Albanian and reflecting only Albanian national feelings. The court found that that's not constitutional because emblem, logo of the municipality should be written in all local languages and should reflect the feelings of all nationalities. But we say it Article 7 of the statute, and then we declare that unconstitutional. They redesigned that so that now the statute of the municipality of Prizren is different and reflects the feelings of all nationalities. The tale of two presidents. I use this expression from Hugo's famous novel. Constitutional Court has ruled twice on presidents, 3 times, in fact, on heads of states of Kosovo. In 2010, we found that the then current president of the Republic was violating the Constitution because he was head of state and head of the party, head of the political party. The Constitution says that once you are elected, you have no right neither to freeze, as he was saying, nor to defreeze, nor to hold or associate yourself with any political party. Then, after 3 days, he resigned. Immediately following this was elected to a person who is now Deputy Prime Minister of Kosovo, was elected as a president, and then we found that the Assembly violated again within 6 months. We said no, it is violation of the Constitution because president should be elected by 2/3 majority, and simple majority can happen only after 3 rounds. But in all 3 rounds, there should be 2/3 of the votes cast there. People should be in the MPs should be in the room. What happened was quite the opposite. He was elected. Procedure was followed, despite the fact that only 61, 62 were in the room. They were going first round failed, second round failed, and third round. So effectively, they were making mockery of the Constitution and the provision which requires 2/3. Why 2/3? Because in countries which have no direct election for the president, for the head of state, which is the most sublime expression of the unity of nation, there should be constitutional mechanisms such as 2/3 or 3/5, which guarantee that he or she would reflect constitutional unity of all the nation. Then it was next, after this, we said there is no precedent. It was unconstitutional the way it was done. Assembly elected in a constitutional procedure Madame Yahyaga, current president of the Republic. It's she. And then it was part of the general political agreement. What happened after 1 year was the politicians said, we want new constitutional amendment which would say after 6 months she goes home. Once the amendments enter into force, current president goes home, so that they elect someone else in direct elections. Then we quashed that amendment and said no, head of state and no constitutional body's mandate can change prematurely with the Constitution by enacting constitutional amendments. That can happen only for those who come after the mandate expires of the current incumbent constitutional organs. And we quoted South Korean Constitution, for example, which has express provision on this matter, which says every change in the mandate of constitutional bodies takes place for those who come. And then we quoted in our judgment decision of France in 2000, after Chirac changed the Constitution from de Gaulle's 7 years to 5, and said this amendment enters into force following the expiration of the mandate of the current French president. And then, of course, politics charged us, said that we are protecting head of state. We are protecting the Constitution. We don't protect ad hominem anyone. So, and then the last is the ratification of the agreement among these cases between Serbia and Kosovo. It's been 1 year ever since the dialogue with Serbs started. In April, there was an agreement between 2 countries, which was brought before us for review. And we said, after it was voted in Parliament, 10 MPs, because in our system, 10 MPs can bring the case, every decision of the Assembly before us, within 8 days. What happened was, they said this agreement should be quashed. And the court said, by quoting 3 systems that exist today regarding the status of the international treaties in domestic system, is continental, it's common law that includes Britain and former colonies, and American, which is mixed, American system. And we said, in continental system, constitutional courts have no right to review constitutionality of international agreements after they are voted, ratified in the Assembly. Because in that case, you would breach the Vienna Convention on the Law of the Treaties. As we all know, it says constitutional obligations of the constitutional provisions of the state cannot be an hindrance to implementation bona fide of the international obligations of state. That would be for us to play a role of international court, which is not allowed. In Britain, every international treaty or obligation, in order to become domestic law, there should be a law with similar name. For example, Human Rights Act, which implements in Britain European Convention of Human Rights. But then, if the court has to review, it doesn't review the international treaty, but the law enacting the which is perfectly constitutional. Then American system, the issue, as you know better than I do, the status of international agreements, as it is said, approved by Congress. In order to avoid that, it was created the doctrine of international treaties concluded by President of the U.S. in discharging of its executive powers, which is different from self-executing treaties which require implementing legislation. So in order to avoid the role of the Congress, there is that type of agreements which are concluded by the head of state, by President of the U.S., only as far as its executive, discharging with executive powers is concerned. So again, we used very comparative perspective, telling those MPs that no, you have no right to require the review of the constitutionality of an international treaty after the treaty has been duly ratified by Assembly. So these were general points. I left many things, of course, which can go maybe hours and hours, and I hope I didn't bother you. I thank you for your attention, and I expect that you would have some comments or questions or whatever, and I'm ready and happy to receive them. Thank you again. Yes, please.
Can you discuss the role of freedom of speech and how it plays into your constitutional structure?
Right. Freedom of speech is provisions of Chapter 2 of the Constitution of the Republic of Kosovo, which is available in internet. If you read them, you would see that they are modeled after the European Convention on Human Rights. On the freedom of speech, we haven't had so far any case before us, so that I would have said you more in detail in the Kosovo context. What I can say is that the freedom of speech provisions from Chapter 2 are more or less the same. In fact, the wording is absolutely the same like the freedom of speech in the European Convention and in other constitutions of former communist countries of Europe. It's pretty much wide, curtailed, and I would, in our conditions, which is again European standard, hate speech would be the only part, because as you know, some of human rights can be restricted. It is said in the Constitution, our Constitution, European Convention, it says if it is necessary in a democratic society for the purposes of preserving the rights of the others, public interest or morale. So I would imagine the situation, and Chapter 3, dealing with the protection of the rights of communities, I would well imagine the situation, because it forbids the incitement of national and ethnic hatred. I would imagine that the hate speech case, we had that in 2000 before we were independent, but then we were ruled by international administrator under the UN auspices, UNMIC. That's a different story. You know, it's not, you cannot speak about constitutional issue those days. But I would imagine that the court might rule in the future, for example, and restrict certain freedom of expression in certain, for example, media or TV channels or whatever, if that is to the detriment, or it's what is known as hate speech in the most general sense. This is more or less the standard in Europe.
And what would be some of the main differences that your Constitution handles with free speech as opposed to the First Amendment here in the United States Constitution?
For example, let's take, which is very current, the issue of the, which is in fact today Western standard expressed in different terms, New York Times versus Sullivan issue. We don't have, so far, we haven't had any case law, neither before us nor before regular courts as far as civil. So that, you know, there is no criminal implications regarding the freedom of speech in whatever form. So this is, it was a temptation last year. You know, government wanted to institute 2 articles which would force journalists to disclose the source of information if that leads to a criminal offense, but that was taken out. So only civil liability. Yes.
Sorry, just to ask a question about that last sentence. So did you rule that it was unconstitutional in your country to force a journalist to disclose
We did. The case came before us, but by the time we wanted to rule, and we would have ruled for sure that they are not constitutional, but the government pulled back the law and said itself, no. Apparently they knew what we will say. This is the decision. This is the general opinion in Kosovo. As far as civil liability is concerned, freedom of expression is absolutely, although there is no experience, and judges, the problem is the difference between our court and regular judges is that in our court almost everybody speaks English. They are all judges and legal clerks that we have educated abroad. So, and we do research. I was talking to the dean earlier. We have access, because one of the judges, we are 9, one of the judges is American from Minnesota. Through him, we have access, unlimited access to Westlaw, for example. It's donation given to us. So we do research as you do and as every court elsewhere does. Of course, your Supreme Court, as you all know, quoting foreign sources would be now, and it is in fact, because you are self-sufficient society in all senses. But the issue of regular courts is problematic for one reason, because they are generation educated in former system. Very few of them speak English, so it would be, for me, very difficult to imagine how they would apply standards of New York Times versus Sullivan and other standards of the freedom of speech and in general freedom of expression. Issue which is associated with that is, which is again in Europe trendy, is issue of the wearing of religious symbols. There is wide margin of appreciation there for national countries, which is quite different from the States. In many countries of Europe, wearing of religious symbols in schools is forbidden, is prohibited. Is prohibited for different reasons. For example, some countries reason it for security reasons. Others, for example, in Germany, for the protection of the rights of the others who don't share the same religion, and the like. We haven't had so far those cases, but I presume we will have, because that's an issue. That's a very hot issue in the region, in general. But we would apply the standards according to our Constitution, Article 53. We are obliged to apply standards of Strasbourg case law, meaning European Court for Human Rights. Whatever they say or have said on all issues of human rights and fundamental freedoms, we have to elaborate, and we quote, as you can see from our decisions in our website, we quote extensively those decisions. You did once, I think it was juvenile death penalty case in the States, and ever since, I guess no one has ever quoted. So, but we are obliged to do it. Yes, please.
You mentioned a couple of examples where the decisions of the Constitutional Court were respected by the other governmental institutions. Have there been some instances where the Constitutional Court has had difficulty getting other branches of government to respect its decisions, as has happened, for example, in Egypt?
Right. No. No. So far, so good. No, we haven't had. And there is a nice book by Ginsberg, Constitutional Justice in New Democracies. He has made extensive research about the strength of the constitutional courts. And what the research shows is this: the more cohesive the political forces are, the weaker the constitutional courts appear, and the vice versa. The more divided political spectrum, political forces are, constitutional courts are more powerful. In fact, this is the case with Kosovo. Government of the last years, ever since we exist, could not project political force cohesively in the way, for example, you would have in Egypt. And besides, social, cultural, and religious cleavages in Kosovo society are by far minor compared to Egypt. So, yes, please.
So, you mentioned there are 9 members of the court. How are they selected? How are you selected?
Right. Nationals, we were voted by our assembly. Internationals had to undergo, in Kosovo used to exist until 2 years ago, ICO, International Civilian Office, which appointed international judges and legal advisors, legal clerks, upon the proposal of the President of the European Court on Human Rights. So, and they were, they have no veto. Internationals are equal with us, and no decision so far has been nationals versus internationals, or the opposite, or Albanians versus Serbs and others, which are in the court. All decisions have always been either consensual or 7-2, 2 meaning internationals on that side, 1 being with us, or dissenting. So it's been very, very colorful dynamic. Yes, please.
My name is Antigona. I would like to ask you for if gay marriage is permitted. I understand the Constitution says 2 people can marry, but it doesn't mention.
That's right. The way Constitution defines marriage, it's very obvious that it allows same-sex marriage without any problem. It's allowed if, you know, or it will be registered. For sure. Of course, the reaction, Kosovo Constitution doesn't reflect this material structure of the Kosovo society. The same is with, for example, Croatia, the same is with Montenegro, you know. That's why our Constitution has, there is a famous American scholar, Ruthie Tittle, it says, schizophrenic role of a law in transitional societies. Law meaning constitution as well. Law has to be predictable, but in our societies, law is at the same time an instrument of change. Constitution is an instrument serves to change Kosovo society and model it along Western lines. As I said, the way we define marriage allows all, in addition to the different sexes, same-sex marriage and other types of living together. The issue would be debated as to the adoption of children and the like, which is more or less the same debate that goes on in some Western societies. But as such, marriage among gays and other same-sex persons is allowed. Yes, please.
Two questions. The first one is, you mentioned that the separation of powers was something that was very important in developing your constitutional structure. Can you tell me more about how the constitutional court and the government systems interact in determining constitutional laws?
Right. In Article 4 of the Constitution, it's elaborated extensively separation of power. It's sanctioned, and it says, for example, what is judiciary, and who exercises judicial power, what is executive power, and who does it, what is the head of state. When it comes to the court, we are not part of the separation of powers. We are answerable to the Constitution only. We don't report to the Assembly. We have full institutional autonomy, independence. We don't report to anybody. Our budget is just sent to the government and approved without any comments, the way we as a court propose. In most of the European countries, constitutional courts are not part of the judiciary. The same is with us. We oversee the work of the judiciary, and we oversee the work of every public authority, whether they apply the Constitution, including Article 4, dealing with separation. We would tell them that you are violating, as we have said, separation of powers to President Seydiu, for example, by holding two positions, or the way second president was elected, or when we invalidate laws, we have reaction from MPs. They say this is interference in our internal affairs, But our argument is always that we are guardians of the Constitution, which includes separation of power as one of the constitutional ingredients of a democratic society. Professor, yes.
Yes, could you say a word about the teaching of constitutional law in legal education? You've mentioned the importance of comparative constitutions. Do students in Kosovo have to consider, for example, the U.S. Constitution?
Sure. Oh, yeah. As I said, we had recently two American professors, Professor Mark Tushnet just 3 weeks ago, and Professor Morrison 2 months and a half, something like that. And they were impressed by the level of knowledge of our students about American Constitution and, in general, Western constitutionalism. As I said, they are young, and they almost 90% of them would speak English. In fact, not knowing English nowadays in Kosovo would be kind of a shame, kind of a handicap, in terms of your social posture, social status among your peers. And constitutional law textbooks extensively deal with comparative aspects of constitutionalism.